Hey, Brian Parker here with another exciting video. This one, it's case study week. What does that mean? Well, that means we're going to look at actual members' cases. Either they're successful, or they're beginning them, or they're in the midst of the case, and we're going to look at their documents and break it down. Today we've got a good one. This is a case against LVNV Funding from a member who successfully fought them and won. And sometimes it goes good with judges, sometimes it goes bad. This judge could see right through the BS, and you will too today. We're going to examine the BS. And this is from New Jersey. And the member wrote me a nice letter and said that she'd won, and she volunteered to give me all the information. So I broke down her stuff after she had and added some stuff for you. And I'll attach all the documents from her and from I to this video at killdebt.com. So this is the lawsuit she faced, Shazam. And right off the bat, we can see a problem with that. Let's emphasize just paragraph 1, Shazam. And that says, defendant is indebted to the original creditor, Credit One Bank. Well, you can't be indebted to Credit One Bank if it's from LVNV Funding. The case would be from Credit One Bank. So that's not even true, and you call it whatever you want. So already in paragraph 1, they're making false representations. So now they try to support that LVNV Funding is the current creditor, if you will, even though they're saying defendant's indebted to Credit One Bank. You can't have it both ways, but maybe they're telling the truth because their documentation showing LVNV Funding owns it is so bad that in a sense the lawyers are saying, well, that's really true because according to the documents, Credit One Bank still owns it. So let's take a look, and you be the judge. You be the judge. So Exhibit 1, that is their first document saying the bill of sale and assignment of accounts from Credit One Bank to MHC receivables. When you see MHC receivables, it's a distressed debt buyer. You see all the time with LVNV Funding and Resurgent. I'm sure they're all connected. Check it out. So they're saying on February 28, 2023, Credit One Bank assigned something from Credit One-Fresh-Resurgent-032023. The computer file. Well, I'm sure that's exactly what it says it is. However, the transfer document, let's put it up there, Shazam, does not say my client or your name or my member's name inside the body of this, whatever it is. But it just says Credit One sold something to MHC receivables. So let's see. Oh, also, it's undated and the signature is a little wonky, but we'll just move on from that. But I'm not so sure that anything's getting transferred, and maybe the lawyers are right when they say defendant still owns this in paragraph 1. So look at Exhibit 2, Shazam, and that's the bill of sale and assignment of receivables from MHC Receivables, they're claiming to have it now, to FNBM LLC. It's another one of those distressed debt buyers that just murks around the bottom of the ocean, and you see them all the time in these type of cases. So they're saying they've sold the debt to, in this weird Credit One-Fresh-Resurgent-032023. By the way, why is it called Resurgent? Why is Resurgent? They're not in this chain of title so far, but whatever. And on March 16th, MHC is claiming to sell something to FNBM LLC. I repeated myself. So this is where it gets to be fun. Let's see Exhibit 3, Shazam. On that same date, MHC Receivables, the one that just sold the debt to FNBM as assignees, sold the same debt, assigned it to Credit Asset Sales LLC, and called them assignees on the same date. And again, it's Credit One-Fresh-Resurgent-032023. New explanation why Resurgent's in that. So my question is, how is MHC selling the same thing to two different entities? Now you got to ask yourself, who really owns that debt and what do they own? And again, none of these assignments or sales or whatever they are, or whatever they purport to be, I like to use that kind of word at least once a video, what they purport to be are what they purport to be, and they're not in any way, shape, or form showing the specific debt of the member's account number or even her name. So let's look at Exhibit 4, transfer and assignment, Shazam. You've probably seen that in your own LVNV case and lots of others. Check out those signatures and compare them online to the same transfer and assignment documents. See if you see what I see. I'll leave it at that. But Resurgent has shown up and said, without recourse to the extent permitted by applicable law, they're selling something to LVNV Funding. Well, if you're selling something to without recourse, you're essentially going, you take this. You can't sue us for this. And sells and assigns and conveys and grants delivers to LVNV Funding all its rights and interests. Well, who gave it to Resurgent? We looked at 4 documents. This is the 4th. And nobody's selling anything to Resurgent. So they do and they know that. So they do a kind of a crafty thing. Look at the end here. They go, and they sell the receivables and other assets, the assets identified Exhibit A. And by the way, the Exhibit A does not identify the client in any way, shape, or form. For purchase by, on March 16th, they're claiming credit asset sales delivered something to them on March 16th. That you remember when the other 2 sales occurred on March 16th. One to credit asset sales, one to FNBM. So they craftily put in this transfer and assignment, delivered by Credit Asset Sales LLC on March 16th for purchase by ARALLC, Resurgent, on March 16th. So there's no assignment there, but they threw in this little language that said delivered by Credit Asset Sales for purchase by. It didn't say it was purchased or when it occurred. It said there's a date for purchase by or what was sold. The transfer of the assets included electronically stored business records, nothing to do with the member here. So the question is, let me put these up. Question, who sold the debt to Resurgent? If Credit Asset sold something to Resurgent, what does FMBM own? Look at what Resurgent tries to do, that crafty language, and look at those signatures. Anyway, so I created for you and for your answer, and maybe attach it to your counter-affidavit, but it really lays out quickly in our ADHD world how a judge with its limited time to look at something can see right away the broken chain of title. And I called it a synopsis, and it incorporates all those exhibits you looked at, and I will put it up. Shazam. On February 28th, the original creditor claims to sell something with that Credit One Fresh thing, Exhibit 1. March 16th, MHC claims to sell something to FNBM. March 16th, MHC claims to sell something to Credit Asset Sales. And then on March 16th, Resurgent LLC claims to sell something inside of it, Exhibits A, to file to LVNV Funding. I write, LVNV has no ownership in the debt. Resurgent cannot sell something it was not assigned from Credit Asset Sales, and MHC can't sell the same debt twice, first to FNBM and then to Credit Asset Sales on the same day. Who owns the debt? You got to have a perfected chain of title. There shouldn't be any ambiguity or questions. There are no account numbers in the debtor's debt or file, so there is no assignment thereafter to LVNV for it to sue the member here. So the member here created an affidavit, a counter-affidavit, nothing more important than the counter-affidavit. And here's what she wrote. I'll just do parts of it. It's modeled on the counter-affidavits on killdebt.com. Number 3, the lawsuit attached several documents, bill of sales, and transferred or sold rights of something to MHC receivables. And she went down the list of what I just wrote. And inside she says, how is it even possible that MHC receivables already sold and assigned their rights to FNBM LLC. Very confusing. She and I did not talk about this. That's what she did on her own. She saw what I just showed you when I created that synopsis. So you will see that too. Number 4, Shazam, there are no good assignments between LVNV Funding and Credit One Bank of an assignment of debt, nor a bill of sale with my specific detailed information. Number 5, there is a transfer and assignment attached to the lawsuit with very confusing language and dates, and the transfer assignment does not mention my specific name. This is all laid out by her without any help of mine, other than going, she's a member of killdebt.com. Here's her answer in affirmative defenses, Shazam, and she writes the famous preliminary statement. You can do that. No state requires you to do it. No state forbids you to do that. It's just, you're really doing the court a favor, just breaking it down, and you're doing yourself a favor as far as presenting an answer and affirmative defenses that means something, because you're always wanting to do what? Create leverage. So when you write an answer, you aren't writing an answer, you're creating leverage. So if you put admit, deny, deny, neither admit or deny, and that's your answer, good luck with leveraging that to get a good settlement out of the bad guy. Now, if you do what this member did, what a problem Parker does, with all the indication of how this is a bad sale and LVNV Funding doesn't own the debt, just chock full of good stuff that creates leverage, you're going to get out of this case. In fact, it was so good what she did, the court literally said and yelled at the LVNV Funding for bringing the case. And I've never seen this before so quickly, but he wrote off the lawsuit with prejudice. A lot of courts, they're sort of they're not as strong as they should be when it comes to debtors. They'll go, hey, look, I'm going to dismiss this without prejudice, LVNV Funding. I'm going to give you a chance to show that why you own this debt. This judge didn't mess around. Because she did such a good job using out killdebt.com stuff, but it's all about her. It's all about her. You can either win or lose upon yourself. Regardless of what I give you as much as I can, but I can't be there for you. But this was her. She created this, and this is her answer. Number 1, neither admit or deny as insufficient information. Now, she didn't just leave it at that. She said, as plaintiff, LVNV Funding has failed to provide any agreement or statement of an account showing a specific debt, an amount or date opened and charged. See that? You can say neither admit or deny, or you can power pack the thing. See Exhibit 1, her counter-affidavit. Denied, as there is no proof of contract of a purchase between LVNV Funding and original creditor. You can read. Look how powerful that is. Now, think about how admit, deny, neither admit or deny. No one's going to pay attention or settle that case. With this, either a court is going to slam them or LVNV Funding is going to smarten up, good luck, and settle with her. Her affirmative defenses were just as power-packed. Shazam. Put you up a couple there. And she's essentially breaking down in affirmative defenses what the court should see legally that LVNV Funding has not met their burden of proof. In fact, number 6, she writes, another entity or bank owns the rights to some assets, purchase accounts, or the debt, as the debt is in a secure trust and is being securitized and not properly transferred or assigned. While we did not touch upon that, and somewhat she didn't either, you have an axiom in the law. You bring it or lose it. So if you can show later on, or you suspect there's a securitization, for example, you got to put it in your affirmative defenses, because if you don't bring it, you lose the right to argue it. So she took all that and won her case. And I'm going to read to you just a small paragraph of several paragraphs she wrote in a statement to me and to you. And I'm going to attach it to killdebt.com so you can read her whole statement. She did this all on her own. She was nervous about, let me just read this. If anyone's reading this and going through being sued, once you get over the initial shock, anger, fear, and what other feelings you may go through, pray, meditate, affirm, and begin to think positively that all will work out in your favor. I had to constantly say this to myself. Positive affirmation, why not? Your brain will do whatever you tell it to. So if you just speak good, positive thoughts, that will be the outcome. I've got this. You either win or it will be dismissed with prejudice or by default, as they won't show. Their paperwork didn't show. I really did have to convince myself and believe this, as I had nothing else except Parker's amazing documentation and education. She wrote that. I also worked very hard at my case, downloading loads of documents and combing through them and drafting my papers and also tearing apart the plaintiff's complaint. That was key. The counter-affidavit is golden. Once you do that, everything else does pretty much flow. There was more. You can read it on the killdebt.com video site. They'll have all these documents, along with the LVNV complaint and their bad documents, the member's answer. Use it being Word, you can use it. A member's counter-affidavit. That counter-affidavit, it's the best way to win these cases or give yourself leverage. Exhibit 1, baby. That'll be in Word for you too to use. My synopsis in Word on the chain of title and how it can show the court that the chain of title is broken. It's true. The chain of title is as strong as its weakest link. Once one is gone, nothing. LVNV Funding in this case can't show that they own the debt, especially when that one bad distressed debt buyer sold it to 2 different companies that didn't. I don't know why they. Yeah, I do know I did that, but that's a whole new video. And also the client statement and my wonderful show notes. When I do a video, how many pages are here? Several pages. I don't feel comfortable unless I put the work in for you to use. So I make sure I've analyzed and carefully looked at what I'm presenting to you so that you can see that I'm putting the time and effort in for you. So this is Case Study Week. First case today, that's on killdebt.com. Don't forget, this month will be the AI of it all. Let's do the little airplane. Parker GPT is coming. It's killdebt.ai because we take the AI out of anxiety. I don't think that's cool. But anyway, so you'll be able to go on our website very soon. And if you want documents done for you, you just put in your information, state law, whatever it is, and put it all in, and up pops the answer. Up pops the letter you need. Securitization letter, creditor letter, all those great letters. Arbitration letter. I'm going to be doing an arbitration video on new rules in arbitration. That'll have an arbitration letter, motion to compel arbitration, blah, blah, blah. Anything you want, any motion we've done, any discovery, any responses discovery, you just go to the killdebt.ai. Boop, 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 and you will find what you need. Again, just add your case law and facts. I hope this has all made sense to you. This made sense. Our member that just did a great job against. I love beating LVNV Funding because they're so kind of so-and-so's like we've got it right here, and it's not. And attorneys sign off on this. But as I said before, maybe the attorney that signed off on this complaint when he said, I think Credit One Bank still owns this, maybe he knew what he was saying. So I know what you're saying if you're a disciple of ours, and I hope you keep rocking this. Thank you very much. Bye-bye.